Good morning, everyone. Again, this is Sue Combs with Holland & Hart. I think that we'll go ahead and get started. So welcome to this morning's webinar, New OSHA Rules Every Employer Should Know. My colleague Matt Linton is co-presenting with me today.
Hello, everyone. Thank you for joining us.
And to give you a brief introduction to Matt and I, we are attorneys in our Workplace Safety Emergency Response team. I am based in our Jackson Hole, Wyoming office, and Matt is based in our Denver, Colorado office. We have attorneys in workplace safety in approximately 10 different offices in the Rocky Mountains and Washington, D.C. As workplace safety and emergency response attorneys, we help a broad range of mining, energy, and other clients when they need help responding to serious incidents that involve personal injury, property loss, environmental releases, and similar events. At the scene, we manage the evidence, help preserve it, help conduct an investigation under the attorney-client privilege, and liaison with the field employees and government agencies if such are involved. Also, we defend companies against civil litigation that may result from a workplace incident or safety violation, as well as defend regulatory enforcement actions, including citations issued by OSHA and MSHA. Less emergent, but nonetheless important, is that we advise clients at the intersection of employment law issues and safety regulatory compliance, which is the topic of today's presentation. To give you an overview of what we'll be discussing today, in May of 2016, OSHA made some significant additions to its injury and illness reporting requirements. The revised rule, you can find it at 29 CFR 1904 at subsections 35 through 41. It imposes new obligations on many employers to annually submit to OSHA their injury and illness data for posting on OSHA's website. That website will be searchable and publicly available. I will be discussing these topics as the first two items of our agenda today. Then Matt will be taking over to discuss items 3 through 5 on our agenda, which discuss that the new rule, in order to ensure that the injury and illness data that OSHA is receiving is complete and accurate, the new rule promotes employees' rights to report work-related injuries and illnesses without retaliation. This aspect of the rule targets programs and policies that, while nominally promoting safety, in OSHA's view, actually has an effect of discouraging workers from reporting their injuries and illnesses, and in turn leading to incomplete and flawed data. Matt will discuss the implications of that aspect of the rule on drug testing, notice of employees of their reporting rights, and employer policies. Last, if time permits, we'll briefly touch on the higher penalties that will be accompanying OSHA citations, and a brief Q&A session at the end, if time permits. Before we jump into the substance today, again, we're thrilled you can join us. I'm happy to be able to talk to so many of you today, and we hope that you find the presentation helpful. Your lines are muted to ensure sound quality. So if you do have questions, feel free to use the Q&A function on the webinar itself via your computer. If time permits, we will answer your questions. Please note that the questions are publicly seen by all participants of the webinar. If you would like to ask us some questions offline, or if we don't have time to reach your question today, we would be happy to discuss those questions or particular concerns that you have offline. My contact information and Matt's contact information is on the last slide of this PowerPoint. CLE credits, we have pre-approved for Colorado and Wyoming for an hour. If you're in a state outside of Colorado and Wyoming and would like CLE credits, would you please contact us offline and we will get you the information that you need for your particular state to help you obtain CLE credit there. Also, we will be providing these slides and some associated materials to all participants after the webinar.
One other little note, we also have SHRM credit that is pre-approved for our HR professionals that are on the call as well.
Perfect, thanks, Matt. Okay, let's get started. Okay, OSHA's new electronic reporting rules. As a place to begin, I'd like to clarify that the reporting rules that we are talking about today do not change your current requirements under OSHA to record workplace injury and illnesses data. A very brief refresher for many of you. Many employers with 10 or more employees must keep a record known as your OSHA logs about work-related injuries and illnesses for each calendar year. There are some certain low-risk industries that are exempt from this requirement. If you're not sure if you are exempt, there's a list on OSHA's website of the exempt industries. It's not very many, and most of our participants on the call, if not all, would not be exempt. Normally, the record-keeping requirement requires the employer to keep the data on site, and it is not provided to OSHA unless in the unfortunate event that OSHA has reason to visit one of your work establishments for an inspection or to investigate an employee complaint or injury. Usually the OSHA logs are the very first thing the OSHA compliance officer will ask for. But the logs generally are not submitted to OSHA except in that instance, and they're not available to the public. Also, what we are talking about today does not impact your requirement to report a work-related fatality to OSHA within 8 hours, or to report an amputation, loss of an eye, or an illness or injury requiring hospitalization of any one worker to OSHA within 24 hours. It's beyond the scope of our talk today to go into much more detail on those record-keeping requirements, but I did want to note that we are not discussing changes to those requirements today. Instead, we're talking about a new burden to now submit to OSHA electronically every year this recorded injury and illness data, and which OSHA will then post on its website and make publicly available and searchable. Who does this electronic reporting requirement apply to? If you are an employer with 250 or more employees, you are subject to the new electronic reporting requirement. What will have to be submitted to OSHA electronically is your OSHA Form 300. That's your log of work-related injuries and illnesses for each establishment. Your OSHA Form 300A, which is the summary of work-related injuries and illnesses, which currently simply has to be posted at the establishment. And lastly, your Injury and Illness Incident Report, your Form 301. Employers with 20 employees to 249 employers have a slightly different burden. Only employers in certain high-risk industries fall within the electronic reporting requirements if they have between 20 and 249 employees. There is a list that is attached to the OSHA rule. It's a fairly long list of who comes within this reporting requirement. It ranges from hospitals, manufacturing, construction, long-term care facilities, retail. It's a very broad list of employees. We will be providing you in the follow-up email with this slideshow a copy of that list so that you can quickly cross-reference if your company is subject to these reporting requirements, if you have any doubt. And you can also feel free to follow up with us. So if you fall into the high-risk industry category and you have less than 250 employees, the only reporting requirement is the Summary of Work-Related Injuries and Illnesses, the Form 300A. The third type of employer who could be subject to this electronic reporting requirement is one that OSHA directly makes a written request to supply the data. To understand the application of this reporting requirement in terms of counting your employees, to count your employees, that means all persons working during a previous calendar year. So that includes your full-time employees, part-time employees, seasonal workers, temporary workers in the company as a whole. Okay, the next slide is a chart that we hope you find helpful to understand the deadlines for these reporting requirements and when the new OSHA rule will come into effect. It is not currently in effect. It will be rolling out in phases. So if you fall within the 250 plus employees category, you'll see that there's a 2-year phased-in requirement. So by July 1st, 2017, only your 300A logs will have to be submitted electronically. The following year, July 1, 2018, your 2017 OSHA injury and illness recording forms, all of them, 300, 300A, and 301, are due. After that 2-year phase-in period, every March thereafter, all 3 of these forms are due. And there's a similar phase-in period that you can see in the second row for employers in the high-risk industries with less than 250 employees. It's important to remember that if you're in a state plan state, such as Wyoming, as opposed to a federal OSHA state, that the state plans must adopt this electronic reporting requirement, so you also will be subject to the same requirements. But I encourage you to confirm that the state-specific OSHA standards implemented match the federal regulations that we're talking about today. Most likely they will be. In Wyoming, it will be exactly the same. Okay, some considerations for you about the implications of having to submit this injury and illness data to OSHA electronically, rather than simply having it located at the physical work site and it being disclosed only if OSHA shows up. Perhaps most importantly, and I've already mentioned this, is that this data will be posted on an OSHA website. We know very little currently about what that website will look like and how it will function and when it will be made available to employers. However, what we have heard is that the data will be publicly accessible, and it will be searchable. So now you have your company's injury and illness data for prior years available to OSHA. So it's much more readily accessible to OSHA. OSHA has said that its intent is to use the data, to mine the data with data analytics, to target employers with high incidence of serious injuries and illnesses. So if you have an establishment with a higher than average injury and illness rate, you have an increased likelihood of being visited by a compliance officer. As many of you probably already know, OSHA has very limited resources. And this is an approach that they feel will help them be more efficient and to go after what they consider the more bad actors. So that's one reason why OSHA is moving to this electronic reporting requirement. Number two, OSHA's goal is steeped in behavioral economics. So their anticipation is that if an employer has to have their data publicly available, they will have more motivation to decrease their incidence of workplace injuries and illnesses. So they will increase safety at their work sites. This OSHA administration has frequently said that one of its most effective tools is regulation by shame. So this is another tactic to use the public nature of this data to help them motivate companies to improve safety. Whether or not it will have the effect OSHA hopes it will is another question. But that's what's driving this electronic reporting requirement. Those two primary goals of OSHA. So the data is already out there, it's already being collected by the employers, but OSHA wants to have it more readily accessible and to use the analytics from it. The public nature of the data also raises some other concerns that we can think of, such as the data being misinterpreted by the media or misused by the media. Unions, if you have a company that has a union reps have access to this data readily. Now, they already have the right to ask for the data from the company, but this just makes it so much easier. Insurance carriers, how, if at all, will insurance carriers use this data? Employees trying to decide what employer they feel comfortable working with. And lastly, plaintiff's lawyers. So those are some of the considerations. Another consideration is knowing that this requirement is coming is to potentially provide your HR personnel or other persons who are in charge with keeping these injury and illness work-related incidents, keeping these logs, is training them on. There are some requirements for the confidential nature of some of this data. And so figuring out as a company how you are going to manage the creation of these logs and making sure that they are submitted to OSHA on a timely basis, and making sure that there is nothing in the logs or in the incident report for the larger companies that somehow creates some type of unintended admission. Going back to I have a question on counting the 250 plus employees. OSHA guidance right now, we do expect that OSHA will provide more and more guidance on this rule as it's applied. The guidance that we have found so far is that the 250 does not require it being active employees. It's any person employed at any time, even one day, for that prior calendar year, is our understanding from the current guidance from OSHA. And just answering another question, yes, OSHA is changing the timing of the deadline for reporting it. So follow that chart as to when the deadlines are. They're changing it during the phase-in period, but after the phase-in period, they're intending it to be March 2nd of each year, instead of the end of the year. And I think what OSHA is doing there is recognizing that to submit your OSHA logs by January 1 for the prior calendar year, that doesn't give you much time to collate those records and submit them electronically. So the intent is to give you until March. Right, and another comment that we've received, which meets with our understanding too, is that the website is not currently available and that it is in development. Answering another question, for the 250 employees count, the OSHA guidance that I have seen is that it is counted for the employer as a whole, not the individual establishment, which is fairly confusing because the recording requirements, your OSHA logs are per establishment, but the guidance from OSHA says that to count 250 plus, it's all of the work sites counted as a whole. We have a good question. If you do not have any incidents, do you still have to submit the forms and reports? I have not seen any specific OSHA guidance on that, but I would anticipate that the answer is yes. And out of an abundance of caution, that is probably the best case. I'll let Matt chime in if he's seen any other guidance.
I haven't seen anything on that precise question, but I think the answer, I would assume it has to be yes. And frankly, it would be to your advantage if you have nothing to report and that's going to show up publicly. Why not? It seems like a good way to go. Right.
And we've seen some questions. We're receiving some questions about specifics of how it will work to post the data to OSHA. Unfortunately, at this time, we don't have those details. We expect it to be coming, and we certainly can provide a follow-up training, if appropriate, about exactly the mechanics of how you will translate the hard copy of your OSHA logs to the electronic website that OSHA will be providing. And yes, to answer another question, you do still need to follow the requirements for maintaining a copy of your OSHA logs at the worksite. It's currently a 5-year requirement. And so think of the electronic reporting requirements as just an additional burden. Just add it to the current requirements that you are complying with. And another question about if employees work in an MSHA-regulated environment, do they count toward the total count for OSHA reporting purposes? Again, there's no direct OSHA guidance I'm aware of on that, but my expectation is yes, that OSHA is not distinguishing it based on whether you're an MSHA facility or an OSHA facility, that for purposes of simply counting the number of your employees. If you have 250 or more employees and you come within OSHA jurisdiction, you would have to meet this requirement. Matt, did you have a different thought or additional thought on that?
I don't have anything to add there. It's a great question. I mean, that's something I think we'll follow up on as well. I haven't seen any precise guidance there, but again, it seems that OSHA is taking a very broad view toward total employee count. So I would be surprised if they excluded MSHA employees, but that's something definitely we'll take another look at here after the webinar, and if there's any sort of a different response, we'll make sure to get that out to you all.
Okay, and not seeing any other questions on the first two topics that I was intending to cover today, I'd like to turn it over to Matt. He has a fair amount to get through this morning with you all, so thank you.
Thanks, Sue. Really appreciate it. And everyone, if I don't answer a question right off the bat, we'll try to handle it at the end, but we'll try to answer things as we go if possible. So let's see here. I think Sue covered this slide. I'm going to go ahead and get started with drug testing issues because this is a huge, huge change. It has been the subject of quite a bit of controversy already, including a lawsuit that has been filed, which likely led to the delay of the anti-retaliation drug testing components. But here is the bottom line. OSHA believes that having a blanket post-incident drug testing policy can be a form of retaliation. The concern is that it discourages employees from reporting workplace injuries or illnesses. And I think that there's some validity there, right? So if you know, somebody is worried that somehow they're going to get drug tested, even if they report an actual incident, even if they, let's say, you know, the use of drugs had arguably nothing to do with it, the fact that that person would get drug tested immediately after reporting, and then let's say they show positive and would be then dismissed or terminated, you know, that would be, in OSHA's view, a potential form of workplace retaliation, thus stifling the desire to get all injuries and illnesses reported. The evidence shows that there is still quite a substantial number of injuries that occur in the workplace that are not reported to the employer. We're not talking about reporting to OSHA here, although there's also, that's obviously the ultimate concern. OSHA wants to know about everything, but we're talking about the report coming to the employer. And so this final rule changes, in some sense, it turns on its head the world of employment law as we know it when it comes to drug testing. Many employers have zero tolerance policies and have blanket drug testing policies. And this is going to have to be carefully considered for each employer in terms of how they want to craft their drug testing policies in this new world. Now, again, there has been a lawsuit filed. It's in a district court in Texas, the same district court that has been somewhat opposed to OSHA in another employment matter. We will see if this lawsuit has any effect on the actual rule. Frankly, I doubt it. This has been something that, you know, has been proposed for some time. The agency went through its rulemaking process, and this is where we are at. The court has not yet issued any sort of a stay, unless I have missed it in the last day or so. Partly, I think the reality is that OSHA delayed the rule, probably to avoid a court-ordered stay. This was going to come into effect August 10th, if I'm remembering correctly. We are now looking at this occurring November 1st, and I would anticipate some additional guidance coming from federal OSHA, and it looks like we do have a couple of, or at least one participant here who's a part of one of our state OSHA directors. I would anticipate each state plan, OSHA, also issuing guidance potentially on possible ways to deal with this. But let's talk a little bit more about it. So if you're trying to review your policy and you're saying if you've got a zero tolerance policy right now, you ask yourself, when can we conduct drug testing now in light of the new OSHA rule effective November 1st? Guidance, the rule provides, and the guidance that's related to it provides that you can test if there is a reasonable possibility that drug use by the reporting employee was a contributing factor to the accident. You could also test if you're required by state or federal law. The big one here are DOT regulations. So your standard requirements for drug testing, Department of Transportation, that doesn't change. If you are under an obligation by state or federal law to conduct a drug test on your employee, this rule doesn't change that. And the other component here, though, that if you are going to perform the drug test, now again, this is outside of what may be required by state or federal law, but you have to, your policy must address the concept, a concept of causality that says, okay, if we think that there was a potential contributing factor from drug use that can be connected to the accident or incident or illness that's being reported, the other thing that has to happen, and this is the real, where the rubber really meets the road, that the drug test would have to accurately identify impairment. And any of you that work in the world of drug, drug testing in terms of getting your employees tested know that impairment drug tests are either not available or are very expensive or are not possible. And in Colorado, where I am, where we have legalized cannabis, this has been a little bit of an issue for longer, I think, than some places, because where we have people now in Colorado, and that's just the ordinary employment context, using marijuana or cannabis, and they show up with a positive presence drug test, that doesn't necessarily mean that person is impaired at that moment. They could have been using the substance on a weekend, and that is where we're going to have real issues, I think, here with OSHA's new rule, because even if we look at this and say, okay, there's been a causal connection, how are you going to figure out what sort of drug test to use that will identify impairment? And I have to expect that there will be a number of vendors that are going to jump on this, and with any luck, hopefully we will see an improved systemic offering of impairment-based drug tests. But again, some of it is, the science is not entirely there yet. So I think there's a big open question here. Now, I'm just going to take a look. There have been a couple of questions. Was this issued as an actual rule, or is it an interpretation? So the actual rule requires that the testing, it's a little confusing. So OSHA's commentary to the actual rule is what really spells this out. However, I think it's been made very clear that that commentary and that interpretation of the rule with respect to post-incident drug testing, that is going to be the way in which OSHA enforces this. And frankly, unless we see a court order a difference, the order that the agency cannot, that this interpretation is somehow outside of its authority, this is going to be the approach that will occur. And there's another factor as well. There's a very recent decision that just came down that actually approved language that was specifically negotiated with respect to post-incident drug testing, and that the agency has taken this interpretation already in the courts, and this is what we are going to have to live with at the moment. So again, this comes into play November 1st, and I encourage everyone to pull out your policies and take a very careful look. This has been the source of much consternation in a number of our clients. There's commentary now appearing all across the internet about this. I think it did catch a lot of people by surprise. And, but that being said, frankly, if you look at, I'm going to move to the next slide here, some of OSHA's guidance on this, some of it is, going to actually be fairly clear. So they give you a few examples. Unreasonable post-incident testing would include, for example, an employee gets stung by a bee. Well, okay, I think we can all probably agree an employee says they've been stung by a bee, they don't necessarily get a drug test. Repetitive strain injury. Okay, maybe. Injury caused by a tool malfunction. That's where I start to get a little heartburn. Who's decided at that point, at the moment of the accident or injury, whether it was a tool malfunction or whether it was caused by some sort of drug use? Same would go for machine guarding. I mean, okay, if there's an obvious lack of a guard, but anybody that's been around this business long enough knows that there are guards, and then there are guards, and then there are, somewhere in between where somebody thinks it's adequately guarded and perhaps somebody else doesn't. And so it's not necessarily a bright line that you might be able to say, again, right after. I mean, the drug testing would need to occur right after the accident. So you haven't had the benefit of an investigation. You haven't had the benefit of any sort of root cause analysis. You haven't had the benefit even of OSHA being there at that point to look at it. So it's, to suggest that it's unreasonable to conduct post-incident testing after an injury related to guarding, I think there's some real issues there, and some of this is really going to have to be, in many ways, resolved, I think, through the courts as cases are decided and people really start to see the different kinds of examples that occur out there. Very good question here. As to whether or not there are current standards, such as with alcohol, that define an impairment level for different kinds of drugs. There is an increasing body of, I think, research about this, but again, as we've seen here in Colorado, particularly in the context of marijuana, what constitutes impairment is very much a complicated question. And so right now, I'm not aware of, for example, at the very least, an OSHA chart or a NIOSH chart or anything like that that's going to define a specific impairment level, because the other issue is we don't know what the test may even be. Different vendors may have different protocols. So there's a lot to be decided here. I'm going to move to the next slide. So again, these are really things we've been talking about, but open questions. Most drug tests don't show impairment. Lack of a blanket policy in a subjective decision-making. So what we have is, if we don't have a blanket policy, you get inherent subjectivity in when to conduct a drug test. Who's going to decide this? Is it the health and safety professional? Is it the HR professional? Is it legal counsel? If we can't, trying to decide, in a sense, a causal connection between a drug, whether something might have been related to the accident, whether drug use may have been related to the accident, is incredibly complicated. And this, quite frankly, might be where we see some courts pushing back against the agency, because it's just going to be especially difficult for employers to know when to actually conduct this test. And in my view, it would be, I would err, frankly, at this state more on the side of performing a drug test if there is any reasonable belief that could suggest that the use of a a substance that can cause impairment, marijuana, cocaine, heroin, whatever it may be, alcohol, obviously. If the use of one of those substances you can conceive of a reasonable basis that the use of a substance could have contributed to the accident or the injury, my guidance would be perform the test, because everybody is going to need to know what specifically happened with that individual. Frankly, I think OSHA is going to want to know. So I think that if we can construct a reasonable basis, this isn't going to hopefully be as painful as perhaps we are all making it out to be, but different area offices also might have different perspectives. So, in Colorado, our federal OSHA office may have a different perspective than, for example, a state plan in Nevada or Utah, where they might have perhaps even different issues with their own state drug, problems that they may have. There might be other factors at play that are driving the agency, for example, to cause more of a hands-off approach. Not hands-off, but more of a conservative approach on the part of an employer. So this is the bottom line, though. The takeaway is, I'll go back here. The takeaway is that policies, if you have a blanket zero tolerance policy, and that's currently written into your employment manual, and that's what you're guiding your employees on, though you need to take a careful look, and you need to reevaluate how you describe your drug testing. Because if the policy says zero tolerance, and then I think that you're going to have an obvious problem then, even if you have a good, reasonable belief to test somebody in a particular incident. OSHA is going to get that policy, they're going to look at it, and they're going to say, guys, we said you couldn't do this. So we got to work on the language and track OSHA's language in terms of only creating this testing environment post-incident where there can be a causal connection. Now, the weird side of the skin, and I'm spending a lot of time on this because I know this is a huge issue, but the weird side of this is we are also in a sort of a new world where in an odd set of circumstances, we now have something where by virtue of OSHA's requirement, you could have a catastrophic accident and effectively not be permitted to perform a drug test, yet you, if there's no accident at all, can have routine, regular drug tests of your employees, because it's not tied to any sort of accident or reporting issue with respect to OSHA. So it really, in some ways, is backwards. It's easier to drug test your employees if they're not involved in a catastrophic accident. I find that to be a little baffling, to be honest. Incentive programs. The other issue we have to deal with here, this has long been an issue for OSHA. There's always been a concept of these employee incentive programs that reward injury-free or injury-free workplaces. There's been talk over the years that these can be considered retaliatory. And I think for obvious reason, again, this is not totally unreasonable. If you have an incentive program that basically rewards no injuries, well, it could very likely, if it's tied to bonuses or things like that, that can cause people not to report. And I think OSHA's done some studies that really show that that's in fact the case. So this has now been codified in the new regs, where it's now within the law that employers may, it's not just guidance, that employers may not use an incentive program to take adverse action, such as to deny a benefit. So again, bonuses, tying a injury, lack of any sort of reportable injury to a bonus program is very likely going to be problematic and run afoul of the new regulations. OSHA does provide a little bit of guidance here, noting that acceptable programs reward employees who correctly follow rules, identify or remedy hazards, participate on safety committees, So really, it's more of the positive reward. I don't know. Think of training your toddler or your dog. You know, with positive reinforcement. Hey, you did a great job this week. You followed our stop work policy when you thought there was an issue. That's something that's going to be acceptable. Tying it to, hey, guess what? We didn't hear a darn thing from you all month about safety. Congratulations, you get a bonus. That's going to be a problem. We have a good question about whether the incentive prohibition extends to corporate level bonuses. That's actually something I think I'd like to respond to after the webinar because it's a little more complicated. Reporting, again, obviously this rule deals with reporting. Reporting is the new paradigm in OSHA land. So I think, again, it's always helpful to me to think about what is driving all of this. And in many ways, it is, frankly, the fact that our health and safety enforcement programs in this country are chronically underfunded. There are not enough OSHA inspectors, not enough MSHA inspectors. Now, employers would probably disagree, and I think, you know, does everybody want the OSHA inspector showing up at their door? Of course not. On the other hand, so the way OSHA is looking at this is they need to get the information. They need to figure out where the problems are. So it's all about reporting. And employee procedures for reporting work-related injuries and illnesses must be reasonable. They can't be too burdensome on a reporting employee. So, for example, there can't be too many steps in reporting mechanisms that could be unreasonable and violate the rule. One example might be something that requires, quote, immediate reporting. Indeed, OSHA doesn't necessarily think immediate reporting with some penalty on an employee makes sense. There probably needs to be within your policy the time frame with which an employee is required to report an injury or illness in order to give them the time to actually do so. If you create an impossible reporting burden, the employee either won't do it or they'll do it and then they'll get penalized for it, which then creates a chilling effect on the reporting requirements in general. So OSHA wants to create reasonable reporting requirements. And part of that is informing your employees of their right to report injuries and illnesses without fear of retaliation. I have good news for you here. Post your OSHA, it's the law poster that you can download from their website. You can order the print version. Sometimes this is going to just be included in whatever you buy from a vendor in terms of all the different posters you put up, but you can meet your notice requirement to your employees by posting the It's the Law OSHA poster in the appropriate conspicuous place like a break room where employees can see it. You might also consider, and I would encourage looking at including this within your employee manual, a statement as to what your injury and illness reporting requirements are, the method by which they are supposed to be reported, and tell your employees what you want them to do and make it easy on them. Again, be careful with discipline policies that can limit or discourage reporting. An example, discipline for failing to timely report an injury that could violate OSHA's new rule if applied to a worker whose injury developed or worsened over time, such as repetitive motion injuries. This is another, so there's a new requirement within these rules that pertains to anti-retaliation measures. Employers have always been prohibited from retaliating or discriminating against a reporting employee. And under OSHA's 11C section, complaints have long been made and investigated related to a whistleblower complaint that somebody has come forward and alleged some retaliation on their employment related to a health and safety issue that they have raised. But there was never a specific and affirmative requirement within the regulations pertaining to retaliation. There is now. Under the new rule, OSHA may issue citations for retaliation and require abatement solely on the issue of retaliation itself. They no longer need to actually file a complaint to start the whistleblower process under 11C. So now OSHA on its own can issue a citation without having to get the actual complaint filed by the employee. I don't know yet whether this is going to really increase the number of citations employers may receive related to this issue, because frankly, this typically would probably only come up in the context of an actual investigation, or excuse me, of perhaps a compliance visit or an inspection, and then as a part of that process, OSHA finds some retaliation violation of the new section. However, I think that's probably fairly unlikely. We're probably still going to most likely see the scenario where you have employees filing complaints. That being said, there's always been this dual process where an employee can file an anonymous complaint about a health and safety issue and not have to before ever filing a whistleblower claim. And so if we have an employee that calls with an anonymous complaint to OSHA, and that anonymous complaint alleges an issue with respect to retaliation regarding reporting, OSHA at that point can conduct an investigation and issue a citation independent of that employee actually coming forward and identifying him or herself as the complaining employee. Question that just came in: are we at risk of anti-retaliation if an employee is disciplined for an infraction of a work rule that results in an injury? The answer to that is yes. I think that's always been yes. So, if an employee, first of all, if an employee violates a work rule and it's safety related, it's probably a very good idea that employee needs to be disciplined. But it needs to be a very careful process, because whenever you are in a circumstance where the employee, either themselves or another, has been injured by virtue of violating a rule, that employee, if they get disciplined, can turn right around and say, well, actually, I raised this safety issue 3 months ago. Nobody did anything about it. Now this happened, and now I'm being retaliated against because of it. So tread carefully. This is an area where it is not only an area of increased enforcement for OSHA with respect to whistleblower cases. Employees know about their rights. In fact, you're required to inform them of their rights, and it needs to be something that is not a knee-jerk response. It needs to be very well thought out and understood that the employee, that there's no connection between the actual reporting of a safety violation, that it's connected solely to the violation of the rule, not the employee's conduct either prior to or after with respect to raising safety concerns. And if that sounds like a very fine line, it is, and it's a complicated scenario. And I know we're getting very close to the end here, so I'll try to wrap up for everyone. We're very close. Challenges to the anti-retaliation rule. As I indicated before, industry groups and associations have sought a preliminary injunction to prevent the anti-retaliation provisions going into effect. That includes the drug testing policies, as well as the new regulatory requirement that now, or the standard for which OSHA can now cite you for retaliation. This is pending in a federal court in Texas. This filing likely did move the date back from August 10th to November 1st. Haven't heard anything that suggests OSHA is backing down, just delaying and giving us this time to have webinars like this so people can get their policies in order and start to try to get their mind around how this is all going to work. Should this court do anything in the immediate future, keep an eye out. We will be monitoring this ourselves. We will issue a client alert as soon as we know about it. If there's something that changes your requirements or delays or somehow affects the rule, and we'll send out client alerts as well as post to our workplace safety report as well. Okay, just very quickly, more good news, and I say that sarcastically. On top of these new requirements, effective August 2nd, today, the maximum OSHA fines are now increasing approximately 78%. The highest willful or repeat violations can now be cited at $124,000 and some change, increase over the $70,000 level. The minimum repeat or willful violation will be going from $5,000 to almost $9,000. These are big increases. There hasn't been much change in a long time, and this is not going to be a one-time thing. Also, it's tied now to cost of living and inflationary type adjustments. It's actually possible that these numbers could go down based on essentially the overall economy. Indeed, on the MSHA side, there are a couple of penalties. They were part of the same budget rule or change this year that increased most of the penalties, but there are some MSHA penalties that actually went down very slightly, but actually went down because of this. It's possible these will go up and down over time, but the new world is that we're dealing with a near doubling of the penalties, and that very likely might change your perspective when deciding whether or not to contest these cases. No raise in minimum fines for serious and failure to abate violations. There's a cap for serious and failure to abate violations, up from the current $7,000 to $12,400, and the penalties are adjusted for inflation in the future. The B&A actually issued a nice and useful chart just a few days ago, and take a look at this. B&A also had an article that was associated with this. It's a nice simple chart explaining where things are going, and you can take a look. A couple of open questions. So these new penalties actually are not, they can apply to inspections that have been performed before today, so long as they hadn't actually been issued as citations yet. I believe it goes back retroactively until this past November. If you were inspected and haven't yet received your penalties, people are wondering, has OSHA held off issuing citations until the higher penalties are in effect? I personally haven't seen that. Most of the time the agency, they're just trying to get through this stuff. So, yeah, there's this question, are we going to see a glut of citations? I don't know. If you have pending citations out there that you think you are about to get, and the inspection was performed really within the last 6 months or so, or going back into the last year, you may see the higher penalties, and that was part of the rule. Certainly worth double checking to make sure all of the requirements with respect to applying it retroactively have been met. But it's possible you'll see that. Again, that being said, I've just recently, a number of clients have received their citations from inspections performed in the last few months. It didn't appear as though anybody's waiting. I don't think OSHA is sitting there, hoping and doing in an evil way to try to go out and get people. I think this is a long-term thing that's going to go into play and need need to factor it in now. But question, will abatement costs continue to exceed penalties? Yeah, I mean, yes and no, right? Probably some will, some won't, but you know, it's often been the case that when advising clients, we have to, you know, let them know that it's not necessarily the cost of the citation that is going to impact their bottom line, but the cost of abatement. And you know, it's just going to, that gap may narrow, but it's still likely that abatement costs are often a lot more expensive than the actual citation. Okay, let's see. I think we are about done. Just a few wrap-ups. Remember, be prepared to submit your data electronically beginning next July. Review your reporting mechanisms for reasonableness. Post your It's the Law poster. Stay tuned for any changes or challenges that may occur to anti-retaliation rules. But review your policies now. Get legal involved, get health and safety involved. Really think through this new paradigm of how this is going to work for your company with respect to drug testing, with respect to the anti-retaliation measures, with respect to encouraging and reporting of accident injuries for your employees. And know that citations will cost you more. So your regular health and safety good protocols are all the more important, not only for the safety of your employees, but for the cost of getting cited here. So we're out of time, but any additional questions, absolutely feel free to submit them. We're going to go through this list here, make sure we've addressed things that we didn't address, and get back to people individually. We have your information based on the way the webinar works, so we'll respond if we don't think we responded adequately, or if you don't think we responded adequately, just drop us a line. This is you know, this is confusing stuff, and it's we are more than happy to try to work through it with you, and you know, we will likely try to provide any other additional guidance we can on a sort of macro level like this webinar leading up to the different deadlines that are now in play. Sue, did you have anything else to add before we close?
No, I didn't. Thanks, Matt. You might want to show them the slide on where they can find the blog.
Oh yeah, thank you. One other yes. So we maintain a blog called the Workplace Safety Report. We work very hard to try to get out information quickly when new things happen. We also sometimes like to post just interesting tidbits, like, for example, the Harrison Ford injury case in the UK that led to a criminal guilty plea for Disney's subsidiary for crushing and breaking Harrison Ford's leg under the door of the Millennium Falcon while they were filming the latest Star Wars movie. Kind of an interesting case if you hadn't read about that one yet. But you know, more importantly, any of the new developments we post to the Workplace Safety Report, and you can subscribe to it. You can follow it, RSS feeds, different ways like that. And that's it. Here's Sue and my contact info. As she indicated, there are several of us that do this work throughout the country, and we are absolutely happy to help in any way we can. Sue, we did get one last question there on the dates.
Sure. The last question is about the dates that we discussed on the new reporting requirements. It is a bit confusing. The chart does represent a phase-in period of 2 years, so that the schedule is being rolled out. So for the first 2 years, the new deadline to report will be in July. So July 2017, July 2018. But starting in 2019, the deadline will become March, and then it will stay March for the anticipated future. So I hope that answers the question. Again, if not, if there's anything else people have questions about, please feel free to contact us offline. And thank you, everyone, for sticking with us a little past 12 today and for joining our webinar. We appreciate the opportunity.
Thank you, Sue. And the webinar recording will be available to you all probably within the next, I would say, 24, 48 hours. We will send out links so you can download it and have it saved however you wish to refer back to, as well as the chart that Sue indicated. We will send that out to everyone about the industries that are the high-risk areas. So with that, thank you very much. We really appreciate you all making time for this. I hope it was helpful, and have a pleasant rest of your day.
Thank you.